Good morning. Welcome to the Worldwide Headquarters. Today we're going to do Class 18, which is the material in Hart and Wechsler between pages 939 and 986. For the most part of this will be about congressional power to abrogate state sovereign immunity. But I want to start at the end of the reading assignment with the 1913 decision of Home Telephone and Telegraph versus the City of Los Angeles. You'll find that at page 981 of the casebook. The Hart and Wechsler editors placed this at the end of the section because it's a good bridge of discussing 14th Amendment state authority, and it serves as a nice segue into 1983 cases that we'll be doing next. But I want to talk about it while Ex parte Young is still fresh in all of our minds. Remember that Ex parte Young was decided in 1908, just 5 years before Home Telephone and Telegraph. Young was based upon the authority stripping fiction that because a state cannot act intentionally to violate the Constitution or federal law, when a state officer does so, she is stripped of she's stripped of state authority, the court said, and thus cannot act with the claim of the protection of sovereign immunity. Somebody in class raised the point, well, if you're stripped for 11th Amendment purposes, shouldn't you be stripped from being a state actor for 14th Amendment purposes? A perfectly valid, logical question, and as we discussed in Young, there's no logic to what Young was doing. It's a total fiction. But the court had to come back to this question about the 14th Amendment stripping proposition in the Home Telephone and Telegraph case in 1913, just 5 years after Young was decided. So again, that's page 981 of the casebook. The case is a lot like Ex parte Young, except it was a 14th Amendment challenge to telephone rates. Same claim that the rates were set too low by the city and the state so that they were confiscatory and thus were subject to a challenge under Lochner for a substantive due process violation under 14th Amendment. The Supreme Court held in that case that although the state officer is stripped of state authority for purposes of the 11th Amendment and sovereign immunity, she remains fully clothed for purposes of 14th Amendment state actor authority. Part of the rationale is found in the material at the bottom of page 983, where the Supreme Court points out that a state actor can violate the 14th Amendment in at least two ways. The first is if she takes an action that it by itself is violative of the 14th Amendment. The second way she could violate the 14th Amendment is that if she pursues a lawful purpose, a perfectly valid state law, but does it in an abusive kind of way, that in and of itself might constitute a 14th Amendment. And the court thought that was an important distinction. But here's the way I kind of look at this fiction issue here. The bottom line may be that if you apply authority stripping to the state actor in the 14th Amendment context, there will never be state action for purposes of the 14th Amendment, and thus the whole thing is rendered meaningless, and that doesn't make sense. So if you say that the state actor is not stripped of authority, you uphold the purpose of enforcing the 14th Amendment. I don't know of a way to fashion the same kind of argument in the 11th Amendment sovereign immunity arena. Maybe there is, but I'm skeptical of it. So ultimately, what we talked about last time, we saw that the Supreme Court moved away from these flights of fiction and recognized in the Volpa case, the Pennhurst II case, and the Coeur d'Alene cases that the authority stripping fiction justification of Young, we didn't need to stand on that anymore. And we replaced it with a recognition that the vindication of federal rights and federal law supremacies are better rationales for what the court has done. So now let me move into the larger topic of congressional abrogation of state sovereign immunity. No one questions Congress's power to give up the sovereign immunity of the United States, but certainly all these cases signal what the fight has been in the state sovereign immunity arena. The cases on this topic are all relatively recent, and the reasons for that is because in the past, Congress simply did not authorize in statutes private lawsuits against state governments, so the issue never came up. That changed in the 1960s when the state authority in Congress was on the wane, and nationalization of politics was a bigger thing. So let's get into this. As I told you earlier, we are going to have, let me back up here and stay on this slide for a second. We're going to look at this as three general buckets of organization. We're going to talk about abrogation of state sovereign immunity when Congress acts under the Fifth Amendment of the 14th, Section 5 of the 14th Amendment. We're going to talk about it in terms of the Commerce Clause, and then finally, there's one significant case in the bankruptcy context that you need to know about. So the Fifth Amendment of the 14th, boy, keep going there. That's early morning recording for you. Section 5 of the 14th Amendment says Congress shall have power to enforce by appropriate legislation the provisions of this article. It's just an authorization statute. So the starting point for this line of cases is Fitzpatrick versus Bitzer, which is a unanimous Supreme Court decision from 1976. You'll find this on page 939 of the casebook. In 1972, Congress extended Title VII prohibitions on employment discrimination to states and local governments. It asserted the authority to do this under Section 5 of the 14th Amendment. And the Supreme Court held that when Congress acts with clear intent, it may abrogate the sovereign immunity of the states, and therefore there could be an award of retroactive benefits and attorney's fees. So, as we'll see, we're going to stress two things. Congress has to act with clear intent, and it has to act under its Section 5 power. So, why is that? Well, for what the court said in Fitzpatrick is that the court noted that the 14th Amendment was all about limiting state power for improper purposes, and Section 5 is authorization to give Congress the power to enforce that. And the states ratified that amendment, so they bought into that notion. Also, it's important to note that you could make this argument in other contexts, but the court in Fitzpatrick also cited an 1880 case, Ex parte Virginia, and essentially says, look, when you make an addition to the power of the federal government, you're giving it up from the state governments, and essentially you're carving it out of the state's power. So Fitzpatrick holds that, well, let me back up here a second. The ruling itself, or the rationale, is not just a deductive argument from the fact that the 14th Amendment comes after the 11th Amendment. Obviously it does, and obviously you could make an argument here that anything after the 11th impacts it. But the difference with the 14th is Section 5, because you have express congressional authorization to act in an amendment that talks explicitly about limiting state power. So it's not just a deductive argument in terms of a timeline, it's the limitation on states that comes in the main part of the 14th Amendment. So Fitzpatrick is the case that holds that Congress can abrogate state immunity when two elements are present. First, you have to have clear congressional intent to subject the state to suit. And there's a later case that has this quote in it, the Atascadero Hospital case. It says, if Congress intends to alter the usual constitutional balance between the state and federal government, it must make its intention to do so unmistakably clear in the language of the statute. So this isn't like a situation that might come out of the narrow reading of Alexander v. Sandoval, where The court alluded to the possibility that Congress could allude to a private cause of action, and that might be enough to imply one. In this line of cases under Section 5 of the 14th Amendment, the Supreme Court says there has to be an unmistakably clear statement in the statute itself that Congress wants to abrogate sovereign immunity. So you have that clear congressional intent element, and then secondly, it has to be action under Section 5 of the 14th Amendment. So a fair question is, would the same rule apply to similar provisions in the 13th, 15th, 19th, 23rd, 24th, or 26th Amendments? In principle, maybe, but the court apparently has not reached any cases under those amendments yet with regard to sovereign immunity, so we don't know. So we're just going to keep on talking about Section 5. So think about for a second the rationale of the clear statement rule and what I just said in terms of the Atascadero quote. The rationale, when you think of that, you think of the big picture of federal courts, the two topics that we talk about, separation of powers and federalism. And the clear statement rule is all about federalism, that sensitivity to those values means that if Congress wants to abrogate sovereign immunity, it needs to be very clear in telling us that's what it wants to do. So by the 1980s, Congress got the message that if it wanted to put states on the hook, it had to be very clear in its language, and it learned to do that. And that meant that the Supreme Court, had a number or more cases to consider just how far Congress could go under its Section 5 power. So to see what's at stake in this, we begin with the case of United States versus Georgia, which is a 2006 Supreme Court unanimous decision. You can find it at page 962 in the text at the top. And it's an obscure case, but it's an important principle here. The allegation is that conduct in prisons was so bad that it violated the inmate's right to be free from cruel and unusual punishment. I see another typo in the slide, and that's driving me mad, so I apologize for that. And it's important here, that second bullet point is important because this was an allegation of a constitutional violation, not a statutory one. And the court held unanimously that nobody doubted that Congress can create private remedies for violations of the 14th Amendment. And it's hard to tell from the text in the book, but this is a case about a constitutional violation. And thus, with regard to constitutional violations, Congress has very broad authority. That's a very important point that doesn't get a whole lot of attention. But the open issue that comes out of U.S. v. Georgia is the question of how far can Congress go in abrogating state sovereign immunity when you're dealing with statutory issues, not violation issues. So you consider what happened in Fitzpatrick, and Title VII itself imposes liability for discriminatory effects, but the 14th Amendment only talks about purposeful discrimination. Fitzpatrick versus Bitzer evidently rules that states can be liable for the former as well as the latter. But Fitzpatrick itself did not even address the issue of the scope of congressional power under Section 5 to impose liability on states for federal statutory violations, which is the question that comes out of U.S. v. Georgia. And that's an issue that the court began to address only in the late 1990s, and the short answer is sometimes Congress can, sometimes it can't. So the issue here is one that is somewhat familiar from con law, which is one aspect of the larger, more general issue of the scope of congressional power to under Section 5 of the 14th to regulate state conduct. And the the practical importance for us is this sovereign immunity issue. Because with regard to, if you put sovereign immunity aside for a second, Congress probably can accomplish almost anything else it wants to without resorting to Section 5 of the 14th. Maybe not everything. You can look at the Shelby County voting rights case for that. All right, so let's go back to congressional power under Section 5 in regulating conduct by the states that does not in and of itself violate the Constitution. And so the general answer that we find is in a case called City of Barron versus Flores, which is on page 959 from the textbook. And in that case, that was the court held that Congress can impose obligations on states, including damages liabilities, for conduct that does not violate the Constitution, so statutory conduct, if there is what the court called congruence and proportionality between, on the one hand, the injury to be prevented or remedied, and secondly, the means, and the means adopted to that end. So, between the constitutional violations through a statute and the remedy Congress adopts. So, essentially what that means is, broadly speaking, the universe of events covered by the statute that Congress passes must not be too much larger than the universe of events that are constitutional violations. More concretely, there are three factors that we need to look at. First, it matters whether it's a general proposition that the constitutional rights underlying the legislation are strong or weak. For example, under standard equal protection doctrine, race and sex discrimination issues would be considered quote-unquote strong, while economic regulation and age discriminations would be considered relatively more toward the weak side of the spectrum. Second, the court's going to look at the legislative process that produced the congressional legislation to see if Congress made a sufficiently strong case that there's a systematic pattern of state violations of the constitutional right, thus justifying a statutory response that forbids even more state conduct than just a constitutional violation. And finally, Congress is going to look at the narrowness or breadth of the statutory provisions. So, the key takeaway on these three factors is that the first factor is probably more important than the latter two, because the latter two are fairly easy manipulated. But the opinions that we'll see here in a second contain all three inquiries. In any event, they're related in that the stronger the constitutional norm, the stronger the congressional case is likely to be, and the broader the provisions can permissibly be. So let's look at a couple of examples because I think they will be helpful. The first one we're going to look at is Kimmel versus Florida Board of Regents, a 2000 case that's at page 960 of the book. The issue was the Age Discrimination Employment Act, which forbids governments and others from discriminating in employment against people over 40 on account of their age. The plaintiffs here, employees of the state of Florida, claim that they received lower statutes on account of their age, which would violate the statute. And the statute itself, the ADEA, authorizes suits against state governments. The substantive constitutional law provision bearing on all this, obviously, is the Equal Protection Clause of the 14th Amendment. Applying the test of congruence and proportionality, the court said that under the Equal Protection Clause, age discrimination gets only rational basis scrutiny. And what Congress in effect tried to do with the ADEA was to heighten the scrutiny. And the court said, but the problem is Congress didn't make the case it needed in order to remedy the comparative small amount of age discrimination that is forbidden under the 14th Amendment. A key premise here is that not very many acts of age discrimination will be equal protection violations, given that the test is a rational basis. So a statute that generally forbids age discrimination and authorized suits against state governments for retroactive relief does not satisfy the court's congruence and proportionality test for a valid exercise of Section 5 power. Now, keep in mind, however, that you can sue everybody else, public and private, just not the state, because the Commerce Clause was a different source of congressional power here. So a question you might think, well, after I've read the Kimmel case, does that mean that states can ignore the ADEA with impunity? And the answer is no, because of something I just said, that the statute can still be justified as under the Article I commerce power, and you can still get prospective relief against state officials under the doctrine of ex parte Young, and that is relief that in effect operates against states. And you can also sue state officials for damages if they ignore clearly established law, probably under 1983. So let's look at another instance here, another illustration, and that's the Hibbs case from 2003, and it's also on page 960 of the text. In Hibbs, this was a sex discrimination case, and the court there upheld the abrogation of state sovereign immunity contained in the Family and Medical Leave Act, which you'll hear abbreviated as FMLA. That act requires employers, including state governments, to allow people to take time off for medical and medical care reasons. The court in Hibbs said there was a stronger legislative record, narrower targeting of the provisions, and also stressed, which I think is the key here, the fact that classifications based on gender are subject to heightened scrutiny. Remember, in the Kimmel case, in the age discrimination context, it was rational basis. Here it has to do with gender, and it's subject to a heightened scrutiny. I think this is the key difference here because, as we've said, the other two factors in the congruence and proportionality test are pretty darn elastic and can be manipulated. So keep in mind a point that we've already made, that any particular plaintiff in an FMLA case is allowed to recover damages from the state by meeting the statutory requirements without necessarily showing that his or her constitutional rights were violated. Fairly recently, one justice wrote to signal that it was time to revisit the congruence proportionality test. Now, if you think about this, you might guess who it could be, because the congruence and proportionality test allows Congress to pass statutes that expand conduct that would be under the Constitution is a violation, but they create statutes to say on the same subject matter the range of violations could be broader. So if you're a justice and you don't like that, you want to be more restrained, you're going to probably be on the conservative side of the ledger. And in this instance, in fact, it was Justice Scalia. If you look at the Coleman versus Maryland Court of Appeals case on page 962, that's a 5-4 decision holding that Congress had not provided sufficient evidence of 14th Amendment sex discrimination to justify the provision in FMLA for taking time off work for quote-unquote self-care reasons as opposed to caring for other family members. And in that case, Justice Scalia wrote separately to urge throwing out the congruence and proportionality test in favor of a much more strict rule that the plaintiff must show a constitutional violation before state sovereign immunity could be abrogated or breached. I don't think that's going to gain a majority of the court anytime soon. And in that case, the 4 dissenters who would have said this was a proper application of the congruence and proportionality test to abrogate state immunity were the 4 liberal dissenters. So that's the line of cases under Section 5 of the 14th Amendment. So we're going to change our focus right now to congressional abrogation under the Commerce Clause. Remember, that's in Article 1 of the original Constitution, so it predates the 11th Amendment, obviously. So we're going to not talk about other powers in Article 1, just the Commerce Clause. So granted that commerce can deprive states of their sovereign immunity when acting under Section 5 of the 14th Amendment, we're going to look at what's the scope of congressional power when it acts under the Commerce Clause. The book does not present this well, so I need to tell you this. Remember always that a key doctrine of constitutional jurisprudential practice is to avoid making a decision on a constitutional ground if you can decide the case by interpreting the statute in a way that doesn't violate the Constitution. So the preliminary step in talking about whether Congress can abrogate state sovereign immunity under the Commerce Clause is to look at the statute to see if that's really what Congress intends, i.e., does Congress intend in this statute to abrogate sovereign immunity? So for many years before the Pennsylvania versus Union Gas case in 1989 that we're going to discuss in a second, the Supreme Court was able to duck an entire group of cases by applying the clear intent rule, saying that Congress had to make it unmistakably clear, even when acting under the Commerce Clause, that it intended to abrogate state immunity. So the approach that I think you ought to take to any congressional statute, regardless of what the source of power is, if Congress is asserting to abrogate state immunity, it needs to say that's exactly what it is doing in the language of the statute, that states are on the hook here. So now what we're going to look at is the first case that addresses this in our readings, and that's the Union Gas case on page 940. So let me get our slides here to that. That case held that the Congress may abrogate the immunity when it acts under the Commerce Clause, and arguably under the pluralities reading, that applies to all Article I powers, but we're not going to go there yet. In the case, Union Gas sued Pennsylvania for part of the cost of cleaning up toxic waste. Union Gas relied on a federal statute that nobody ever says the name of, so I'm going to say it here: the Comprehensive Environmental Response, Compensation, and Liability Act of 1980, known as CERCLA. It was clearly an exercise of congressional power under the Commerce Clause, and a 5-person majority of the court found that Congress could abrogate state sovereign immunity when acting under the Commerce Clause. Now, most people treat this as a plurality opinion because Justice White, the fifth vote here, wrote separately to say that he agreed with the holding but disagreed with a lot of what the plurality opinion said. Excuse me. So I think you can view this as a plurality opinion and take that with a grain of salt. And this was the high water mark for the anti-state sovereign immunity wing on the Supreme Court. So what we're going to see first with that background is we have the Union Gas case in 1989. And it holds that the Commerce Clause is a source of congressional power that can be used to breach state sovereign immunity. Then we have another whole line of cases very quickly after that that just destroy everything. You can call it another retrenchment, although in this instance it was an actual overruling. The Seminole Tribe case at Hart and Wexler at page 940 and following overrules Union Gas. And I got to tell you, I do not know why they devoted so many pages in the case book to this case. It's an important case, but boy, is it dry reading. So let's talk about what happened here. In Seminole Tribe, the issue was whether Congress could subject the states to suit under the Indian Gaming Regulatory Act, which was enacted under Congressional Article 1 power over Indian commerce. That's actually known as the Indian Commerce Clause. It's a complex scheme to obligate states to negotiate with Indian tribes about gambling, because Indian tribes have their own form of sovereignty, and it required states to deal with Indian tribes. And that's why you now have, in places like Cherokee, North Carolina, you have gambling where you don't have it anywhere else in the state for the most part. And the Seminole Tribe held that apart from Section 5 of the 14th Amendment, Congress may not abrogate the 11th Amendment immunity when it acts under Article 1, and I would add any other 1787 original Constitution sections. Now we'll see that this does not remain the rule, but this is what happened in Seminole Tribe. So the question is, why not? Well, as I said, the opinion's pretty boring and dry and opaque, and we're going to see in a minute that the Alden v. Maine case from 3 years later in 1999 provides a better explanation of the issue. So essentially, let me give you this summary. Most of it's devoted to questioning the authority of the Union Gas case, which it ultimately overrules. But the basic explanation for Seminole Tribe is pretty straightforward. Hines versus Louisiana is the relevant precedent, and Hines forecloses congressional authorization. So remember that the notion in Hines versus Louisiana is that the sovereign immunity is baked into the constitutional plan. And since it's built into the Constitution, Congress just can't take it away through an Article 1 action. So, but the problem is Article 1 powers are also in that Constitution, so that's kind of a conflict. And so the question goes, how does locating the immunity in the original Constitution, like Hines does and like the majority in Seminole Tribe does, justifying striking down this legislation or this portion, or I should say justify striking down the attempt to sue the state of Florida here, given that the Article 1 powers are also in the Constitution? Well, not clear, but here's what I think. As the Seminole Tribe Court sees it, the immunity not only exists in the 1787 Constitution, but the point of Hines is that the immunity trumps congressional Article 1 power, takes priority over them. Otherwise, the reasoning would go, the constitutional baked-in protection of state sovereign immunity would just be hollow and worthless if you can just point to Article 1 and say, well, Article 1 says I can act. So Seminole Tribe's pretty dry. Another point that we need to look at is how does the opinion distinguish Fitzpatrick? And look at the bottom of page 944. The key here is that the time sequence is that the 14th Amendment, which was enacted right after the Civil War, did partially abrogate the 11th because it fundamentally altered the balance of state and federal power. And in part, that's the deductive timestamp argument, that the 14th came later. Everybody knew about the original Constitution. They knew how it had been interpreted. The 14th changes that. And by contrast, the reasoning goes is that one part of the original Constitution cannot abrogate another part of the original Constitution. So Article 1 powers baked into the original Constitution through the explicit text cannot overrule or trump state sovereign immunity, which is somewhere baked into the Constitution, although we keep pointing out that there's nothing in writing about it. So now let's look at the dissents, because I think they're important. They got 4 votes. The central theme of the dissent is that Hans is wrong. Hans is wrong about holding that state sovereign immunity is a constitutional guarantee. And instead, it should be treated like a variety of federal common law. And remember, one of the questions I asked in the classes on federal common law is for you to consider whether it was derived or driven by a constitutional provision and thus was overarching and could not be changed by Congress, or whether it was derived interstitially, perhaps, to fill in a gap in statutory law and thus was tied to statute, which Congress could absolutely change through subsequent legislation. So the argument that the dissent makes is that in adopting or ratifying the original Constitution, the state gave up some of their sovereign immunities. And a list of some of the prerogatives they gave up is sovereign immunity in lawsuits based on federal law. And then secondly, because sovereign immunity is not a constitutional guarantee, Congress can make statutes that override it. So there are 4 votes for that in Seminole Tribe. So the question is are there still 5 votes on the court for Hans? I think that depends on Gorsuch and Kavanaugh. I think you can count on Thomas, Roberts, and Alito being pretty solid, and probably Gorsuch. Kavanaugh, I think it's a bit too early to tell. But there are also 4 solid votes on the court for limiting state sovereign immunity to the what we call the diversity theory that Justice Brennan has put forth on several occasions. There have been 4 solid votes on that side for the past 30 years. So the question will be what happens when probably Justice Ginsburg and Justice Breyer step down, who are the oldest on the liberal wing of the court. So there's going to be a sharp and persistent disagreement that keeps going. It's interesting that everybody has access to the same historical materials, but the historical materials are ambiguous. Sometimes they don't say anything, as we'll see in a second. So everybody looks at them through their own ideological lenses, and they see different things. There's the view that I think Wilson Parker, in his great jurist class, is very fond of extolling, which is the Blick view. Everybody, I think that's a psychologist, everybody sees the world through their own experiences and their upbringing and the formative experiences that they've had. And that's exactly what's happening here. In any event, the basic truth about this whole thing, I think, is that the courts have to make a rather simple value choice between state autonomy on the one hand and congressional power and state accountability on the other hand. So this is an issue that has only arisen in the last 50 years or so, and accordingly, I don't really think it's a choice that the framers gave much thought about, and I don't think the court in Hans thought about it, and I don't think history tells us a ton of it. So ultimately, it may be one that has to be resolved by a continuing reference to modern policies, and it's pretty much inevitably a political choice with a pretty naked value judgment. So let's move on from Seminole Tribe. Given that the 11th Amendment does not, by its terms, forbid suits in state court, can we avoid the holding of Seminole Tribe by suing in state court? And the answer is no. You need to go look at Alden versus Maine, which is on page 967 in the textbook. In that case, it involved a Fair Labor Standards Act claim for overtime pay. And the court held that you could not get recovery against the state for money owed. And the majority opinion in Alden contains a much more elaborate defense of state sovereign immunity against congressional abrogation than we get in Seminole Tribe, which is interestingly tied to a strange choice that the authors make by giving so much formal space to Seminole Tribe and then just doing Alden v. Maine for several pages in the notes. So the court says, nope, the 11th Amendment says nothing about this, so the broader concept of state sovereign immunity applies. And what happens here, let's get to the reasoning. The basic argument is from Hans versus Louisiana, that sovereign immunity is a root principle, and it's not immunity from suit in federal court. It's not the explicit language of the 11th Amendment that counts. It's the broader principle of sovereign immunity, which is one of the reasons why I don't like the shorthand phrase 11th Amendment. I prefer the broader phrase sovereign immunity. It's interesting that the court in Alden alludes to rejecting, the quote here is ahistorical literalism. And that's coming from the conservative side of the court, who favor textualism, if not more. So it's ironic that that's what we see. And they also talk about the discredited history of Chisholm. Well, if history is the guide, you would expect these more conservative folks who tend to the originalism side of the interpretation scale to look at history. The problem is the court can't point to anything said in the conventions or the ratification debates about immunity from suit in state court, which is what Alden was about. And the court, you can ask the question of why are the Constitution and the debates surrounding ratification silent on immunity in state courts? The majority's answer to this seems to be that the Congressional Convention and ratification debates, that the notion of state sovereign immunity was so ingrained that people took it for granted, and it was like you don't have to say the sky is blue to make it blue. So the court also makes kind of an indirect argument from precedent that state sovereign immunity in state courts is also a premise for Hans and Ex parte Young. And it relies on a structural argument that the structure of the Constitution preserves state sovereign immunity in various ways, including suits against the states, whether in state or federal court. Also, there are some other points from Alden that you need to know about. There is some practical points. The court says these suits in state court would threaten the financial integrity of the states, because they'd have to spend money to pay judgments, but that's true about any lawsuit. They also say that state courts would, allowing suits in state courts on federal grounds would even interfere with the principle of representative government, because it would because by making state courts accountable to, making state governments accountable to courts would interfere with their accountability to the electorate. I think that is so stupid, because accountability can be to different people at different levels. So this, in many ways, this is just, I think, a terrible decision. Finally, we need to look at a case that we haven't discussed much before, but we have mentioned, which is Reich v. Collins. Reich is discussed at pages 757 and 975, and it's a case that holds that a state, when collecting taxes, has to have a due process remedy for taxes collected in violation of federal law. There's got to be a way to get them back or to avoid having to pay them in the first place if it's in violation of federal law. So the Reich case says the state can provide a pre-deprivation due process procedure or a post-deprivation due process procedure, but it's got to have one that allows the taxpayer an avenue for challenging the state tax system on that ground notwithstanding sovereign immunity. Now, the court in Alden said that Reich v. Collins is still good law, that the state could still be compelled to furnish a remedy for constitutional violation in situations where no federal remedy may be available. The logic is not totally clear to me on this, because if state sovereignty is a bar to a suit based on federal law authorized by Congress, and thus implicating the Supremacy Clause, then why isn't the same thing true of a suit claiming that a state tax violates the Constitution? But that's an open question. So let's turn now in the Alden case to the four dissenters. And we've seen this argument before. It gets 4 votes. The notion, again, is that Hans is wrong in claiming that immunity applies against suits based on federal law, at least in situations where Congress has abrogated the immunity with a clear statement of intent, and that the only constitutional immunity that states have is sovereign immunity against what I keep calling the diversity suits brought against them by citizens of other states on state law grounds. So finally, we need to turn one more time in terms of topics, and that has to do with the abrogation of sovereign immunity in the bankruptcy context. Because after Seminole Tribe and Alden, it looked as though the doctrine on congressional abrogation was that Congress could nullify immunity only if it acted under Section 5 of the 14th, and it could reach conduct that would not itself be a violation of the Constitution only when it met the congruence and proportionality between a pattern of constitutional violations and the congressional remedy enacted through statute. But it appeared that Congress could not subject states to suits in state or federal courts when acting under Article 1 powers. But, as I mentioned a few minutes ago, that the statement in Seminole Tribe on that no longer is a completely accurate description of what's happened. And for that, we need to look at a case called Central Virginia Community College versus Katz, which is a 2006 opinion that's on page 963 of the textbook. And this case, like Alden and Seminole Tribe, will be a central case in any sovereign immunity issue that you encounter in your practice over the next few years. In the Katz case, the state, or in this instance, the community college system, which is an arm of the state, as we discussed earlier, was one of several creditors in a bankruptcy filed by a firm called Wallace's Bookstores. They ran the campus bookstores at the community college at issue here. Katz is the trustee appointed by the bankruptcy judge to gather in all of the assets of the bankrupt Wallace Bookstores so that they could figure out who was going to get what in terms of pennies on the dollar. And one of the things the bankruptcy trustee does is he looks at the payments that the bankrupt person or entity makes in the few months right before the filing of the bankruptcy to see if any of the creditors got an unfair payment called a preference, or you could reference as preferential treatment. The notion being that you're looking essentially any payments made 90 days before the bankruptcy are subject to being clawed back by the trustee. So in this instance, Wallace Bookstores had made payments to the community college system, and the bankruptcy trustee, Katz, wants them back to be brought into the common pool of assets to be paid out to all creditors. And under the federal bankruptcy laws I've just alluded to, that's what the trustee's supposed to do. He's supposed to go get preferential payments back. And the state is claiming in this instance that Congress cannot authorize suit against it under an Article 1 power. Bankruptcy is an Article 1 power. So the question is, who wins? And in this instance, the Supreme Court holds that the bankruptcy trustee wins. He can sue the state to get preferential treatment. So Next question has to be, well, Seminole Tribe says you can't do that. You can't act under Article 1 to abrogate state sovereign immunity. So is Seminole Tribe overruled? No. The court instead distinguishes Seminole Tribe. And the key here in doing that, so granting at least implicitly that Seminole Tribe is still good law, that the court limits the ruling in that case to congressional action under the Indian Commerce Clause, and doesn't and determines that it doesn't speak to other Article 1 powers, that to the extent it does so, it's dicta. So what the court in Katz reasons is that states, when the states adopted 1787 Constitution, they did give up their immunity from suits under statutes enacted pursuant to the Bankruptcy Clause, and that it reflects the state's acquiescence in the grant of congressional power to prioritize having a uniform system of bankruptcy laws. Essentially, the plan of the convention being that the state gave up immunity from suits in this area. So is the holding here that Congress can abrogate immunity when acting under the bankruptcy power? No, it's not. The ruling is the state gave up immunity as to bankruptcy, as opposed to Congress having some additional power. And the question is, well, does that have any practical difference? Well, maybe, because the whole clear statement rule in principle would be irrelevant when abrogation is not the theory by which the immunity claim is derived. If Congress is going to act to abrogate, there has to be a clear statement. So, as far as I know, there's no clear statement in the bankruptcy statute, but that's all a bit unclear. But the notion here is you don't have to have a clear statement when abrogation is not your theory. And that's why that distinction makes a big difference. Because when the notion under Katz is that the states gave up immunity by adopting the Constitution with the bankruptcy power in it, and therefore you didn't need a clear statement. But if the theory, the power behind your theory is that Congress has the power to act, to abrogate, then there must be a clear, unmistakable statement of intent to abrogate that authority. That's why that distinction does have a practical import here. So also at the part of the Katz opinion, there's a statement about the in rem nature of bankruptcy being a factor here, that it's this is a narrow instance implicating a different ruling. So the court leaves itself some out. So it may be a ruling just for bankruptcy because of those kinds of statements, but for the sake of thinking about what happens next, let's put aside the possibility that the case is just limited to the bankruptcy context, and let's look at the possibility instead that it could be applied in other contexts. Thus, if you can make that argument, Katz is the first step to getting rid of or limiting the reach of Seminole Tribe and Alden. So if I'm a lawyer for somebody with a claim against a state under a statute enacted under the Commerce Clause, for example, the Fair Labor Standard Act in Alden, can you use any of the reasoning for Katz to urge an exception under the Commerce Clause statute as well? Well, the key sentence or the key notion is the one I mentioned to earlier, that a narrow jurisdiction that doesn't implicate state sovereignty to nearly the same degree as other kinds of jurisdictions. So, for example, if harmonizing bankruptcy law was a pressing goal, which is what the Katz opinion talks about, then can't you make the case that national regulation of interstate commerce was even a more pressing goal? And if the former argument about bankruptcy trumps state sovereignty, shouldn't the latter? For all I know, you might be able to make an argument that powers encapsulated in the original Constitution on a case-by-case basis should be viewed as trumping state sovereign immunity. For example, what if Congress imposed liability on states in a statute enacted under the War Power? And you might come to the conclusion that it's pretty easy to see that a court adopting the reasoning of Katz in this context, after all, is one where the states gave up their immunity in terms of a national war power kind of thing. So, how likely is Katz to be the beginning of the end? Well, the vote that changed, that gave the victory in Katz, was O'Connor. And so we don't know until other people retire how often things will change. You have the differences. You don't know how Justice Alito votes on these because no cases have come up since then. And you obviously have the additions of Justices Gorsuch and Kavanaugh. So who knows? I do think that lawyers will make the kinds of arguments that we've suggested above, that in Commerce Clause and other contexts, and we might see more Supreme Court cases aimed at dealing with the tensions between Seminole Tribe and Katz. So that is a line of reasoning that you could well see in the future, calling you to think about how you can take Katz and extend it towards supplanting Seminole Tribe and Alden. So a long discussion of congressional abrogation of state sovereign immunity. I hope the slides are helpful. If you have questions, let me know. Again, we will next do in class section 9 or class number 19, the section on Section 1983 litigation, and then we'll move on to official immunity. So this is the last class on state sovereign immunity. That ends this session. Have a great day. I look forward to seeing you in class.